Now, you and I, when I was part of the information, we conversed a lot.
We did.
On telephone, never in
Of course,
person.
first time we met was earlier, yeah.
Yes, my personal question to you is this. As a citizen, we've heard Mr. Mirage talk about the reasons behind FOI and the purpose for it.
Yes.
And I could go into the reasons as being myself as to the importance it plays citizens getting access to information in the government. But as a normal person, how difficult or easy it is to get information from a normal public service?
Well, it depends. Let me just start off I'll start with you. When you were there, and I forget the exact year, it was maybe almost 10 years ago, when you were there, Mr. Maraj was head of the Freedom of Information Unit. And I used to pick up the phone and call, and I used to speak with him. And I used to get him. He used to take my call. And he would help me. He was actually somebody I felt he was committed to answering my questions, informing me, assisting me. It was clear I was speaking with somebody who was no lawyer, but he was really working. I didn't mean to say that. That came out wrong. Sorry. It's just to make sure you don't fall asleep. I keep you on alert, right? I didn't really mean that. Yeah, but it's clear I was speaking with someone who was committed to assisting me, and it was a pleasure speaking with him. And it was equally clear a little while later that he was no longer there. I don't know what happened. I mean, I met him for the first time when I came into the room this evening. So it's a pleasure to meet you. It is a pleasure to meet civil servants who are committed to working with the public and doing so in a really straightforward way. So he was one of those people. Now, taking it forward into the depth of the question you asked about how easy and how difficult it is, it depends. To give a Trinidadian answer is according. We had a situation here. Let me give an example. Let's talk about a current case. We had a situation that was on the front page of the Sunday Guardian 2 Sundays ago about our complaint about illegal actions by the Ministry of Justice in relation to the construction, our being JCC, about the Ministry of Justice in relation to the construction, or the proposed construction of judicial centers, which are courthouse complexes throughout our country. And we had a meeting with Minister Volney, 1st of May 2012, a big argumentative meeting. We wrote him on the 7th of May 2012. And he never replied to it. It was a long letter, about 11 or 12 pages long, detailing what our concerns were about the project's illegality and the improper use of public facilities and so on. And I followed that up with a Freedom of Information application from the JCC to the Ministry of Justice. But one of the tactics that we're exploring with some success is there's a limit to how much you could get out of the politicians. Because really and truly, it's a little bit of a kind of a, you know that game at the Savannah where they do like this? And they move it around and then the thing is under this one and it's under that one? It's like a little bit like that. So in fact, you may have targeted this politician for a particular line of questioning. And a month later, the person is not there. For whatever reason. Another person is there and that person will look you fixed in your face and say, well, I wasn't there. That was before me. That was Tom. Or that was Betty. So in fact, what we have taken up, at a certain level of the struggle, we change gears and we target the permanent secretaries. So I targeted the permanent secretary with the Freedom of Information application with a list of questions. And to my astonishment, she took 2 months to answer. The Section 15 of the Act says you have 30 days to answer. But she took 2 months to answer. To my astonishment, that individual, on the letterhead of the Ministry of Justice, under her signature, confirmed in writing 3 illegal things the Ministry of Justice did. Under a different permanent secretary, if you see what I'm saying. A different permanent secretary had done it. It happened under the administration of a different permanent secretary. And the one who was sitting in the seat at the moment, who had been in the meeting, the hot meeting we had with Volney, and was obviously very uncomfortable. When she got the FOI, which gave her the legal window to speak the truth, she did. So, for example, she confirmed that there had been no technical review of the development brief before it was issued. She confirmed that there was a sole selective situation in which there was no tendering for the professional services. She confirmed that they paid over 3 million Trinidad and Tobago dollars in professional fees, when in fact the ministerial committee has a limit of $1 million under the Central Tenders Board Act. And I have that in writing. And that formed the platform for us to go to the Central Tenders Board, the Integrity Commission, and the DPP, And that is how that ended up on the front page of The Guardian Sunday 2 weeks ago. So in fact, it is according to who you write to. In relation to CL Financial, one of the biggest documents I've ever gotten under the Freedom of Information, the biggest, grandest, the most, explains the biggest scandal in the history of the Caribbean. I got it under the FOI after 8 months with no lawyer. I was writing to the Ministry of Finance to get a copy of the CL Financial Shareholders Agreement. That was signed on the 12th of June 2009. And there was a press release from the ministry signed by my good friend and my colleague, Conrad Enel, who was sitting in for Nunes Teixeira at the time. And the contents of that press release made me very uncomfortable. It said certain things I wasn't happy with. So I wanted to see the shareholders' agreement. So I wrote to the Ministry of Finance. And again, I took the same avenue. We wrote to the PS. I didn't worry with the Minister of Finance because those are politicians and there's a kind of a way that they deal. That you could deal with them at a point and then you have to change gears and change from them. And it took her about 6 or 8 months, but that permanent secretary, she's now retired, Alison Lewis, that permanent secretary sent me the whole shareholders agreement. And the shareholders agreement lays out in graphic detail the scandal that we are dealing with. Because we have a shareholders agreement in this country. Let's explain what it is. The company was bankrupt. They were on their knees. When they approached the central bank, it was a scenario that in the financial and commercial language, you described the central bank as being the lender of last resort. In other words, nobody else would lend you any money because you were so broke. It's like when you leave home and you have to go back home to your parents and ask them for money. And it's a question of pride. Nobody else would lend them any money. So it was like a version of Reanimators or vampire movie. They just had enough life to crawl up to the central bank and ask for money. And we were told that the money that was being accessed from the Treasury was being accessed. This is in the bailout of January of 2009. Was being accessed to assist depositors and pensioners and all of that comfortable stuff and granny and tanty and those kinds of things. Only to discover on the 12th of June 2009 that they had signed a shareholders agreement that in fact promised in writing under the signature of the Minister of Finance and the shareholders of CL Financial to restore the shareholders. And wait for it, you're going to see it soon. The only place on the planet, this is the only place on the planet that they had an agreement like that. To restore the shareholders were down to zero. That company could have been bought for $1. That is the commercial and financial reality of what that means. But we had a Ministry of Finance here in June of 2009 that signed our treasury over to restore the shareholders. That's what we're dealing with here. And this is why I'm really involved in our campaign to explain this to the public. We have a public, and I'm not speaking to anyone here in particular. I'm just speaking about a public question. We have a public internationally and nationally that is financially and economically illiterate. We have to become literate. Time to get down to business, mental self-defense and fitness. We have to get down to it. Understand what it is our country at stake. It's our money. And deals are being cut. So on that occasion, that permanent secretary in the Ministry of Finance gave me the document. I didn't have a lawyer's letter. There are other times when I've used lawyers and we go on and on. Round and round we go. Where it stops, nobody knows. So it depends.
If I may just...
Sure.
I'm glad you said that because when we were drafting the Freedom of Information Act, there was a lot of suggestions that we should not make it so simple. And they wanted to make it that you had to have a lawyer's letter. And that is why you'll see in the Freedom of Information Act, you do not need a lawyer's letter.
There's a form, yeah.
It's a form.
Right.
And you do not have, if I might show you, do not have to pay a fee.
No,
It's free.
don't.
It's free.
It's free.
You know, it's free.
Because the whole purpose of it was for members of the public not to have to go to a lawyer. You only go to a lawyer, I suppose, when it is refused.
Yes.
And you need the help of the legal profession. And there's where the legal profession should have been more accommodating.
But my question to you, Mr. Miraj, and afterwards, Mr. Raymond, do people understand their rights under the Freedom of Information Act? And I premise it on this point. While I was there, I came, if I remember, the stats well, from 2007 till 2012. I think the average amount of Freedom of Information requests you get in any given year was about 120, 130. And of all the Freedom of Information requests that have ever been made within the years that the Act has been working, one particular organization alone, one single organization alone, gets about 75% of all the requests. And I'm sure nobody here, neither you all, can tell me which organization that is. It's the Public Service Commission, which means that public officers are utilizing the Act a lot to get information, I guess, on themselves. Because as you mentioned earlier, before the Act, a lot of public officers had problems seeing their personal file and other personal information about them held within the state. So a lot of public officers are using the Freedom of Information Act to get information on themselves. But that aside, 25% are from normal citizens on the street. That can't be enough. Do people really understand their rights under the Act?
I don't think that a lot of people are aware of the power they have under the Freedom of Information Act. And I do not think that people have really utilized it as it should. And that is why I say that it probably needs a very proactive public education program in the communities. And the networking has to be really in the communities. Because if persons are explained, a lot of people do not know that if they go to the hospital to get a medical report and they cannot get it, the doctors cannot say you can't get it. So I think that what is really needed is for the younger generation, if I may say so, to get involved, because this involves the future of the country. And a lot of this information, which can be got, what Mr. Raymond is talking about, can assist in dealing with issues of misconduct in public office, corruption, and abuse of office. As a matter of fact, I don't know if you remember, in whatever year it was, I can't remember, but the information that I saw on CLICO, which was being hidden, I thought that action had to be taken. But if that information was outside to the public over a period of time, I think the members of the public would have been able to understand that this situation should not have developed. And if that action was taken by the government I belonged to at the time, probably we would not have had the CLICO problem that we have now. But information is important. It belongs to the people. It is owned by the people. It's government-held information, but the people own the information, and the government holds that information in trust for the people. So the people are entitled to the information. The problem we are having is that people are not sensitized to the need to use it. And you cannot only blame the people. I come back again to the professionals, and especially the legal profession. This should be a challenge for the legal profession to get more involved in helping people to use the freedom of information. As a matter of fact, in my experience, as a practicing lawyer now, what I do, I get the information from the public service first. And when I get that information, then I advise the filing of the judicial review application. Because in judicial review, you do not get disclosure from the government. So if you have the information and you even write the pre-action protocol letter, it is very difficult for them to contest the matter because you already have the information. But if you write them, they try to suppress the information, and sometimes the information disappears. So, so I hope I've been able to answer.
It's true, it's true.
Do you think people understand?
No. I think that is the reason, that the lack of understanding, the lack of general understanding about the Freedom of Information Act and its potential is one of the reasons that I would take a pause here to congratulate the colleagues who have made the effort to establish this group disclosure today. This is very important because it resounds with Ramesh's point about the responsibility of professionals to assist the broader public to understand what their rights are, and in fact what the possibilities are within the law, of course. So that's a very important step, a very commendable step. I congratulate you. I am appreciative of the fact that you're recognizing my work on this occasion. If I could say something about the Act and about the operation of the Act and yourself, your own role, Rishi, one of the things I've always considered to be a tantalizing possibility, playing around in the back of my mind, in that place where I play with things that could be and should be and so on, is the whole question of how does the Act operate? And how can we introduce management techniques to make the Act operate better? I had suggested some time ago to some colleagues of mine, it doesn't matter who they are, that in fact we need to have a Freedom of Information application into the Freedom of Information Act. So we need to be able to construct a matrix that says, since this Act came in, how many applications were made? To whom? What's the average time it took to respond to those applications? Which are the ones that went to court? Which are the ones that went all the way up to the Privy Council? We need to be able to construct some kind of a matrix to understand how this whole thing operates. Once we have done that, you'd be able to identify the ministries or the public agencies which in fact have a good performance in relation to the Act. So they possibly have ministries or agencies that consistently respond within the time limit of 30 days given in Section 15. What are the methods those ministries or agencies are using as opposed to other ministries or agencies? Now we introduce the concept of benchmarking in management. Okay? How do we actually get a continuously improving public service and continuously improving public administration in terms of our channels for citizen participation? So in fact, we need a freedom of information process ongoing into the freedom of information process. That's what we need to do to get to the next point of understanding what it is going on. Okay, and this is why an organization like the one that you all have come together to establish could, if I could suggest to you, could play an important role in that, to bring some concrete information forward. Because I know I'm from a family of, I'm a descendant of a family of civil servants. I don't have any contempt for the civil service. I was a civil servant myself for years. I know that not everybody in the civil service is evil or bent on cheating the public. I understand that. That's my family. I understand that. I'm not any hostile person to the civil service. But wrong is wrong and right is right. And we need to have a systematic, data-driven method for singling out those who are performing and those who are not performing. Let's go back to the beginning of the discourse about the discourse that we continue to have that lacks hard information. Therefore, it affects our conceptual ability. It affects our ability to have a proper quality conversation. So we need to apply that to the Act itself, as opposed to applying the Act to things external to the Act. The Act itself and the unit itself needs to be subjected to that kind of scrutiny so we can take the performance up to the next level.
Well, I mean, to defend the unit, I mean, I know we do.
I wasn't attacking you.
I
was just saying.
I mean, we have a website, www.foia.gov.tt. Even though I'm not there, I'll still plug it because it's close to my heart. And we have all the annual reports that were done, I think, up to 2010.
Yes.
That at least gives you some statistical information on how much requests were made for that particular annual year.
Yes.
The agencies that got them, the time frame that took less than 30 days, more than 30 days.
Yes.
But I agree, we do need to do some more. I mean, while I was there, one thing I wanted to do was to do an evaluation, a proper evaluation on the Act, because, I mean, the Act was passed in 1999.
Yes.
A lot of countries now have gone beyond and have done different things with legislation. We are now, whereas before we were the forerunner, now we're lagging behind.
That's true.
And maybe we need to now reevaluate freedom of information or move it to the new term now is access to information, or the right to information, and see what other countries have done to bring us now up to that standard. I mean, I know one thing that we've attempted to do with regards to data protection legislation, the Data Protection Act, which deals with the protection of private information, is that we propose to set up an information commissioner, working on the model of the UK. And the UK has an information commissioner, which is a separate independent body that administers both data protection and freedom of information. And if somebody feels that they are aggrieved by a decision of a public body, they can go, instead of going to court, which is always a last resort, they can go to the Information Commission to seek redress. And the Information Commission has a lot more teeth. Information Commission, it's cheaper because it's a public sphere. So that's the approach we took with regards to data protection, that we've moved the freedom of information appeal legislation away from the Ombudsman, because the Ombudsman really has no say. I mean, the Act says that public authorities could, if they want to listen to the Ombudsman, they will have to take on the Ombudsman. Moved away from the Ombudsman, so that you now appeal to this Information Commissioner, who can then look at your case. It'll make it a little more easier, but those are still things that I know they're currently working on, so I really can't get into much. But that's proposals, at least while I was there, we proposed that we move away from the Ombudsman to this Information Commissioner, while still having the court as a matter of last resort.